There are two methods of creating a trust. You can do that in your will. It's called a testamentary trust, and it becomes effective when you die. Your will just contains some additional provisions that say, this is what I want to happen. I want to create this trust when I die, and this is how I want it to be managed. Or you can create a trust during your lifetime, and it's called an inter vivos trust, or a revocable living trust. That type of trust becomes effective immediately when you sign it, and then you transfer your assets into it. As I said, a living trust takes effect during your lifetime, and it acts as a bucket to hold your assets. It also contains your instructions on how to distribute your property at your death. Missed one there. In every living trust, there's three positions. There is the grantor, and that's the person who establishes the trust. Here in Louisiana, we call that a settlor because we call everything something different. And then you have the trustee. That's the person who manages the assets in the trust. And lastly, there is the beneficiary. That's the person who gets the benefit of the assets in the trust, or the one who gets to use the assets. So if you ever get a choice about whether to be the grantor, the trustee, or the beneficiary, choose the beneficiary, okay? You want to make sure you get to use the property. During Tom and Cindy's lifetime, if they had a living trust, they would hold all three positions. They would be the grantor, the trustee, and the beneficiary. After one of them passed away, the other one could retain control of the assets, and they could be the successor trustee, or they could name another successor trustee if the surviving spouse was unable to do that. After both of them were deceased, they could appoint someone else to be the trustee of that trust. In this case, they would probably appoint Mary, and she would manage that money in that special needs trust for Paul so that he wouldn't be disqualified from his benefits, and also manage that money for Peter so he wouldn't use that money to harm himself. And that brings us to the second evil of estate planning, or what I call death probate. Here in Louisiana, we call that a succession. And that is the process to transfer title to your assets from a deceased person to his heirs. While you're living, if you want to sell any of your property, you want to sell your house, you want to sell your car, you usually go before a notary and you sign some papers saying you're selling it or transferring it. Of course, after you're deceased, you can't do that. And so somebody has to sign some papers to make the transfer. And that's the judge who signs it. He signs a document in that succession proceeding that transfers your assets. In a succession, there's an inventory required of all of your property. And a succession is required anytime that a deceased person owns any real estate or any property worth more than $75,000, regardless of whether he has a will or not. A lot of times people will do their will, they'll execute their will, and they'll think, well, I don't need a succession now. But that's not true. If you have a will, it's just going to tell you or tell the judge who you want your property to go to. You're still going to have that succession proceeding if you own any real estate or have more than $75,000 in assets. So what are the fees for death probate, or the fees for a succession? They can be very different. Many states have something called a percentage of the estate method of calculating attorney's fees. In those states, the attorney is entitled to a percentage of what the gross value of the estate is. So if the estate is worth $1 million, it's usually going to be somewhere between 1 or 2%. If it were 2%, then the attorney would get $20,000 as their fee for doing the probate. Louisiana has what's called the reasonable compensation method for determining attorney's fees in a succession. Who do you think gets to decide what's reasonable? Well, it's really the judge, but the judge is usually friends with the attorney, and I've never seen a case where the judge questioned whether it was a reasonable fee or not. So here in Louisiana, you'll find fees done in many different manners. Some attorneys charge a percentage of the estate method. Some charge an hourly fee, and some charge a flat fee based upon how difficult the succession is. Most of the successions that I do, I charge a flat fee on. We got a few that we charge differently, but most of the time we just charge a flat fee. But if you ever have to do a succession for someone, you're going to want to make sure you understand what the attorney's fee is up front. I've had clients who come in after they've hired someone and they found out the fee was a percentage of the estate and it cost them $10,000 to $20,000 when the work that attorney did was no more difficult than had their estate been very much smaller. And so you just want to make sure that you know what those fees are before you hire someone. So what's best for me, a living trust or a will? Well, I'm an attorney, so I'm going to give you the answer that I usually give. It depends. A will is going to ensure that your property goes to the people you want it to go to. A will by itself is not going to protect your young or irresponsible heirs. It's not going to protect from creditors, divorces, or other dangers. Whereas a living trust may do those things, or a trust will do those things. In addition, a living trust is also going to provide better disability protection. You can give someone the right to manage your affairs through a power of attorney. So I can give a power of attorney to Richard and say, Richard, if I can't manage my affairs, I want you to do that for me. But Richard may go to the bank and say, well, I'm here to take care of Linda's banking account. And they say, well, we don't really like that power of attorney. We're not going to honor it. So the bank doesn't have an obligation to do that. Most of the time they will, but not always. If instead your property is in a living trust, they don't have any option because legally the trustee owns the property. So if instead my property was in a living trust and Richard were the trustee, the bank couldn't say we don't like your trust because he actually owns the property. Also, a fully funded living trust, one that you've transferred all of your assets into, is going to avoid probate. And so you're not going to have that death probate. You're not going to have those expenses. But it really depends. Some people, a will is sufficient. Sometimes you may want to do a will that creates a trust at your death. And sometimes you may want to do a living trust. If you own property in more than one state, if you own property here in Louisiana and maybe in Texas or Florida or somewhere else, you're probably going to want to do a living trust because if you don't, you're going to have probate here in Louisiana and also in every state where you own real estate. And so by creating a trust and putting that property from those other states into that trust, you can avoid having multiple probates. And so that's one instance where a living trust is going to work better. There are also some other instances, but it's going to depend upon what your particular situation is. Now that we've talked about